Hey, Mike.
I'm doing very well. I hope you're doing well as well. All right, so, this is an interesting case. I mean, first of all, I don't know how he's gotten this far, but for this particular instance where we're talking about illness and the problems of being a defendant when you can barely, I mean, I know he can't walk. He had a myriad of problems, as the defense attorney called it, bladder cancer. He had esophageal cancer. He has coronary artery disease, AFib. I mean, just all kinds of problems. And there's really no statutory standard for when a situation like this calls for a case to be held over or a trial to be stalled in this instance. I'd love to get your thoughts on how a court should handle a situation like this.
Well, first of all, there is only a constitutional right that I'm aware of to be mentally competent throughout the proceedings. Absent some type of mental absence or mental infirmity where he cannot understand the nature of the proceedings or rationally cooperate with counsel because of a mental disorder or mental defect, having a physical malady or ailment can be accommodated. We very frequently have jurors, for example, who have bladders the size of a peanut. They have to take potty breaks every 15, 20 minutes. We have young mothers as jurors who need lactation breaks. We have diabetic jurors who need to take their insulin. This defendant, if he is writhing in pain, can take a brief recess to take a painkiller or to deal with his pain. But we cannot just simply abate the proceedings to accommodate that. And moreover, in LA County specifically, in the county jail, they have a secure floor within the county USC Medical Center to accommodate any medical problems that might come up with an inmate that's housed in the jail. They bring them there to a secure floor. They get seen by doctors, by surgeons. They do imaging studies. They give them medication. And if, God forbid, they need surgery, they're fully equipped to deal with that. We also have many clients who are wheelchair bound. We have courtrooms dedicated exclusively for wheelchair clients and defendants. We have clients who are on a gurney, quite frankly, but they are mentally sound. So I don't think that under the law that this motion is going to get granted.
So if it doesn't get granted, well, we're then faced with this difficult question of you have a jury that's been sitting out for over a year, and who knows what they were exposed to. So it is really a unique situation for these jurors. They've been impaneled for more than a year, as I said, and the defense has actually filed a motion asking the judge to revoir dire them and when they report back for the case next week. And I want to show some of the questions that they want asked. One of them is, how has the pandemic affected your life? Another one is, have you received a COVID-19 vaccination? Also, do you believe it is safe to hold a jury trial in LA now? Now, since the trial stopped, have you read, seen, or heard anything about Mr. Durst? Interesting questions. Love to get your thoughts on them. I mean, there's some that focus on the mental aspects of the pandemic, which I think are relevant. And then, of course, I think it's very relevant to find out if they heard or found out any additional information about the defendant.
Yeah, well, first of all, any juror can be reoriented. They can be reintroduced to the evidence. They can be questioned regarding hardships. But moreover, if you were to start anew, you'd have the same problem with a brand new jury pool. You'd have to ask them, have they been vaccinated? Have they been tested? Will they wear a mask? So I don't really see any difference between going through the motions with an existing jury that's already been impaneled than starting anew. It doesn't make sense. It would be a tremendous waste of resources. Additionally, what people forget is jurors also have a right to serve. This jury went through a very, very rigorous Q&A. They sat through very, very lengthy voir dire. They sat through opening statement, which I think was, probably a couple of days. They listened to 10 witnesses. I think you would have the same problem regarding the pandemic with any jury panel. But also, the court has dealt with this specifically as it relates to this case. The matter was transferred to the Inglewood Courthouse to Department 1 because it's a very, very large courtroom that could handle such a long cause matter. And they can spatially distance the jurors appropriately to allay any concerns that the court staff, that the bench, and of course that the jurors and the parties might have about being too close to one another. But additionally, the room is not going to be occupied quite so densely by media, by public spectators. It's going to be very, very, very limited because of this raging virus.
You know, what's interesting is you mentioned that opening statements and a number of witnesses, I believe it was 10. Do you think those should be called again? Are we expecting these jurors to remember what they heard, or do you think it's worth, certainly as a defense attorney, you would want maybe these, that sort of redo of opening statements and the witnesses, would you not?
Yeah, I don't have a problem with redoing the opening statement because in a life case like this, with all the peremptory challenges that are allowed under California law, and especially in a pandemic, it could take over a month to pick a new jury. By going through a little Q&A about the COVID-19 epidemic, refreshing their recollections as to what was already presented, reacquainting them with the evidence, maybe even doing a brief reopening, I think would cure it. Again, you would have the same problem with a brand new jury.
Yeah, that's absolutely true. Now, is this something you've come across before? Because it sounds to me like, I mean, these types of problems, certainly it's novel to the pandemic, but I'm sure there were other instances where, for whatever reason, there had to be long delays in trial. Have you ever come across anything like this and found that it works smoothly?
I had one situation some years ago where I had to declare a doubt about a client's mental competency to proceed. And the proceedings were abated during jury selection long enough for the client to be seen and to be given a clean bill of health. And it took a few weeks, but certainly not of this lengthy magnitude. I've never had a trial delayed by a year, 14, 15 months. But it's not to say that it cannot be done. And regarding your point as to the media, again, everybody, regardless of the previously impaneled jurors, has been exposed to the Durst case, either by watching the HBO special or by watching that film that the director had done before the Jinx, or just because of regular news clips about the pending trial. So again, you're going to have the same media throng attention with a new pool of jurors. And to start anew, I think would be a waste of this big crop of jurors.
All right, Philip Dube, thank you so much for those insights. Truly appreciated. Great insights. Actually, right now we're going to take a break, so stand by. We have a lot more ahead in this hour.